goes, uh-oh. The Executive Overreach Task Force will come to order. Without objection, the chair is authorized to declare recess of the task force at any time. And I'll begin with my opening statement. At our first task force hearing, we explored how Congress itself over the past many decades has acted or not acted in ways that have tended to cede its legislative power to the executive branch. Contrary to our founders' original intentions, Our second hearing focused on just some of the many examples in which the President has exercised sometimes sheer will to wrest legislative authority from the United States Congress. Our third hearing today explores even more such abuses. One of the most egregious abuses in the executive branch's handling of the Internal Revenue Service, which was used to restrict the ability of organizations dedicated to educating people on the Constitution and the Bill of Rights to obtain tax-exempt status that they are allowed by law. A report by the Treasury Department's own Inspector General found that organizations that were involved in educating on the Constitution and the Bill of Rights were singled out for adverse tax treatment by the Internal Revenue Service. Other groups with the term progressive in their name were not subject to the same adverse treatment. Adding to the horror of the IRS's abuse of its regulatory authority to favor political supporters of the President is research indicating that politically biased favorable treatment may have significantly affected the 2012 presidential election. Researchers at the American Enterprise Institute and the Harvard Kennedy School of Government found that Republican candidates in the 2010 elections enjoyed huge success when organizations educating people on the Constitution and the Bill of Rights were left unfettered by the IRS. That cycle brought the Republican Party some 3 million to 6 million additional votes in House races. As the researchers concluded, that success was not the result of a few days of work by an elected official or two, but it involved activists all over the country who spent the year and a half leading up to the midterm elections by volunteering, organizing, donating, and rallying. Much of these grassroots activities were centered around 501c4s, which, according to our research, were an important component of Republican success that cycle. The researchers concluded that if those grassroots activities had continued to grow at the pace seen in 2009 and 10, and had their effect on the 2012 vote been similar to that seen in 2010, they would have brought the Republican Party as many as 5 to 8.5 million votes compared to Obama's victory margin of 5 million. But that didn't happen. Instead, in March of 2010, the IRS decided to single out for special adverse treatment groups that educated citizens on the Constitution and the Bill of Rights that contained the word patriot in their names or that otherwise indicated subjects unappealing to the current administration. For the next 2 years, the IRS approved the applications of only 4 such groups, delaying all others while subjecting the applicants to highly intrusive, intimidating requests for information regarding their activities, their membership, their contacts, their Facebook posts, and private thoughts. As the researchers found, quote, as a consequence, the founders, members, and donors of these adversely affected groups found themselves incapable of exercising their constitutional rights, and their impact was muted in the 2012 election cycle, close quote. The IRS abuse had cost these organizations thousands of dollars in legal fees and swallowed the time these all-volunteer networks could have devoted to voter turnout, to outreach in Black and Latino neighborhoods and other events to educate the public on the Constitution and the basic concept of political and individual liberty. Adding insult to injury, a federal lawsuit brought by organizations harmed by the IRS's misconduct has been marred by delays on the part of federal government attorneys so unreasonable that the Sixth Circuit Court of Appeals wrote as follows in an opinion issued just last month. Because of its significance, I will quote it in length. Among the most serious allegations a federal court can address are that an executive agency has targeted citizens for mistreatment based on their political views. Now, no citizen, Republican or Democrat, socialist or libertarian, should be targeted or even have to fear being targeted on those grounds. Yet in this lawsuit, the IRS has only compounded the conduct that gave rise to it. The plaintiffs seek damages on behalf of themselves and other groups whose applications the IRS treated in the manner described by the Inspector General. The lawsuit has progressed as slowly as the underlying applications themselves. At every turn, the IRS has resisted the plaintiff's requests for information regarding the IRS's treatment of the plaintiff class, eventually to the open frustration of the district court. At issue here are the IRS be on the lookout lists of organizations allegedly targeted for unfavorable treatment because of their political beliefs. The district court ordered production of those lists and did so again over an IRS motion to reconsider. Yet almost a year later, the IRS still has not complied with the court's orders. The lawyers in the Department of Justice have a long and storied tradition of defending the nation's interests and enforcing its laws, all of them, not just selective ones, in a manner worthy of the department's name. The conduct of the IRS's attorneys in the district court falls outside that tradition. Those are chilling words, close quote. Those are chilling words from a federal appeals court which found the Justice Department under this administration has failed to enforce the nation's laws and has failed in a manner unworthy of the department's name. I look forward to hearing from all our witnesses here today on these and other issues. The chair would now recognize the ranking member for his opening statement.
Thank you, Mr. Chair. Today's Executive Overreach Task Force, or President Obama is still president, we shall continue the lashings. Congressional hearings, what a clip show is to a television series. In the absence of an original idea or coherent focus, we simply go and re-air snippets of tired old storylines from long ago past episodes. Seinfeld Part 1. Or TBT, hashtag. It is simply sad that at a time when our nation and our world face a host of daunting challenges, the Zika virus, problems in the Middle East, this Congress has chosen to spend its time and taxpayer money on political theater. It is telling that today's hearing has no focal point. Its only purpose appears to be to give conservative critics the opportunity to once again assert that President Barack Obama has acted beyond the law. And as part of a longstanding pattern of attempts to paint this president in particular as somehow illegitimate, going all the way back to the 2008 campaign. This is the week that Passover starts on Friday, and we say, why is this night different from all other nights? Well, why is this president different from all other presidents? I think we all know why. Simply too bad for the critics that the facts do not support their arguments. On the alleged targeting of conservative groups by the Internal Revenue Service, extensive investigations by 2 congressional committees, the Department of Justice and the Treasury, have concluded the IRS did not break the law. Indeed, the Justice Department wrote to the committee on October 23, 2015, its conclusions worth noting at some length. We conducted more than 100 witness interviews, collected more than 1 million pages of IRS documents, analyzed almost 500 tax exemption applications, examined the role and potential culpability of scores of IRS employees, and considered the applicability of civil rights, tax administration, and obstruction statutes. Our investigation uncovered substantial evidence of mismanagement, poor judgment, and institutional inertia, leading to the belief by many tax-exempt applicants the IRS targeted them based on their political viewpoints. But poor management is not a crime. We found no evidence that any IRS official acted based on political, discriminatory, corrupt, or other inappropriate motives that would support a criminal prosecution. We also found no evidence that any official involved in the handling of tax-exempt applications or IRS leadership attempted to obstruct justice. I'd like to ask unanimous consent to include the Justice Department's October 23, 2015 letter in the record.
Hearing no objections, so ordered.
Thank you, thank you. Our Democratic colleagues in the Oversight and Government Reform Committee reached similar conclusions after that committee's extensive investigation on this matter. Committee staff report prepared by Ranking Member Elijah Cummings concluded that after, quote, detailed, lengthy, transcribed interviews of 39 witnesses, including Republicans and individuals with no political affiliation, unquote, there was, quote, no evidence of White House involvement, unquote, and, quote, no evidence of political motivation in the IRS part. Unanimous consent to place in the record the Democratic staff report on the Committee of Oversight and Government Reform entitled No Evidence of White House Involvement or Political Motivation in IRS Screening.
Also hearing no objection, so ordered.
Thank you, Mr. Chair. The majority has picked the wrong president to pick on with the IRS. It's a long time ago, but all we got to go back to is Richard Nixon. And he was real good at using the IRS to punish his opponents. And there would be real bipartisan agreement that we could have examined him and said that was a bad time and the IRS was used by Richard Nixon. It is taxpayer money that pays for this national defense. It is taxpayer money that pays the salaries of federal law enforcement and intelligence officers. It's taxpayer money that pays down the national debt. It's taxpayer money that pays for Medicare, Medicaid, and Social Security, and crop subsidies. And it is the men and women of the IRS that ensure that millions of Americans get their refunds and tax credits. And it is the men and women of the IRS that ensure that we have the money to discuss these and many other critical things. As Justice Oliver Wendell Holmes said, taxes are what you pay to live in a civilized society. And taxes are fine, and you've got to have an IRS, and the whole idea of abolishing is poppycock. Like the IRS matter, the litany of other issues the majority raises in today's hearing is just a repeat of past complaints about agency actions. The fact of the matter is the administrative process includes numerous checks, including judicial review on an agency's actions and its interpretation of its authority to act, and critics offer no credible evidence that these checks have failed. Instead of wasting time, limited time that we have on a hearing about these 9 issues, we should be considering substantive issues like how to tackle over-incarceration, how to end gun violence, how to help students managing crushing student loan debt, and how to help people be part of the American dream. You have a right to vote. Regrettably, these issues sit by the wayside while we engage in this purely political exercise. Further deponent saith not. I yield back the balance of my time.
I thank the ranking member of the task force, and I now yield to the chairman of the full Judiciary Committee, Mr. Goodlett from the Commonwealth of Virginia.
Thank you, Chairman King, for convening this 3rd hearing of the Task Force on Executive Overreach. Following up its last hearing, the topic today includes more recent case studies of the abuse of executive power, and I'll focus my remarks on the President's actions regarding the implementation of the work requirements in the bipartisan welfare reform laws and its unilateral rewriting of federal energy laws. In 1996, President Clinton and a Republican Congress signed into law the Bipartisan Personal Responsibility and Work Opportunity Reconciliation Act, which created the Temporary Assistance for Needy Families Program, or TANF. This program was designed to discourage dependency and encourage employment by placing certain restrictions on welfare. TANF provided that individuals could only receive benefits for up to 5 years and also required recipients to engage in work within 2 years of receiving benefits. The work requirements in particular were recognized as the reason for TANF's success in helping millions of Americans get back to work. Welfare rolls were decreased by half, and the poverty rate for African American children reached its lowest point in U.S. history. Researchers studying the self-reports of happiness by former welfare recipients have shown that these work requirements increased the happiness of single mothers taking part in the program, concluding that the package of welfare and tax policy changes targeting single mothers and generally promoting work increased single mothers' happiness. The observed increase in happiness appears to result from both an increase in single mothers reporting a high level of happiness and a decrease in single mothers reporting a low level of happiness. The magnitude of the effect appears quite large, end quote. These new workers confirm what many studies of human happiness have shown, and that is that one of the best means of achieving happiness is through earned success. As other researchers have shown, paid work activities provide social contact, a means of achieving respect, and a source of engagement, challenge, and meaning. The Obama administration, however, in a mere memorandum issued by the Department of Health and Human Services, deemed it that states no longer had to follow TANF's work requirements and could dispense welfare even if recipients didn't meet the TANF statutory standards. In the 1996 welfare reforms, Congress provided a list of which statutory provisions the federal government could waive, and TANF's work requirements in Section 407 were not listed as waivable. In the many years since the 1996 Act was passed, no administration had ever asserted this authority because the statute's clear text allows for no waivers of TANF's work requirements. The result, if waivers were fully implemented, would be more dependency and less of the sort of earned success that leads to greater happiness. The Obama administration has also attempted to unilaterally impose energy use rules on the states without congressional authorization. Initially, 26 states and now 29 states asked the Chief Justice of the Supreme Court to intervene immediately to stop this abuse, and the Supreme Court promptly stayed the enforcement of the President's plan pending a resolution of the constitutional challenges against it. Even prominent liberal law professor Lawrence Tribe, who taught President Obama constitutional law at Harvard Law School, wrote the following about President Obama's Clean Power Plan. Quote, after studying the only legal basis offered for the EPA's proposed rule, I concluded that the agency is asserting executive power far beyond its lawful authority. Even more fundamentally, the EPA, like every administrative agency, is constitutionally forbidden to exercise powers Congress never delegated to it in the first place. The brute fact is that the Obama administration failed to get climate legislation through Congress. Yet the EPA is acting as though it has the legislative authority anyway to re-engineer the nation's electric generating system and power grid. It does not. End quote. I look forward to hearing from our witnesses today who will discuss these and other abuses of executive power and the means of preventing them. Thank you, Mr. Chairman.
I thank the chairman of the gentleman from Virginia and now yield to the ranking member of the full committee from Michigan, Mr. Conyers.
Thank you, Chairman King. Members of the subcommittee, when the committee first established this task force, I expressed hope that we could work in a substantive and bipartisan manner to address serious questions about relationship between the executive and legislative branches. I continue to hold out that hope, but I am disappointed that so far the task force, to me, seems mostly to have been the kind of partisan political exercise that I was afraid it might be. This is especially so coming after hearings attacking the President on the Patient Protection and Affordable Care Act and immigration, and attacking the very notion of regulatory agencies themselves. Today's grab bag collection of topics, which appear only intended to support the claim that the Obama administration is lawless, only deepens my disappointment. To begin with, none of the investigations into the actions of the Internal Revenue Service in assessing the applications for tax-exempt status by certain conservative groups has identified any illegal conduct. In short, despite numerous hearings, witness interviews, and document reviews, including by congressional committees and by the Departments of Justice and the Treasury, no one found that the IRS or its employees broke the law. Yet just last week, we heard at least 2 members of this task force call for the impeachment of the IRS commissioner from the House floor. And this week, the House will be devoting much of its floor schedule to legislation designed to impugn and undermine the IRS. The real scandal here is the waste of taxpayer money in the majority's continued pursuit of this non-scandal. Likewise, today's hearings also raises to me the unsubstantiated specter of the undeserving welfare recipient. Denigrating the poor as undeserving is a way to score points, I suppose, with some conservative voters. Notwithstanding the fact that the administration has the authority to waive work participation requirements of the Temporary Assistance to Needy Families program. Section 1115 of the Social Security Act specifies that the Secretary of Health and Human Services may waive certain of the requirements for state welfare programs, including those requirements the states themselves claim are onerous and may even undermine the goals of the welfare amendments enacted in 1996. Indeed, 3 years ago, the House passed legislation to prohibit the Secretary of Health and Human Services from granting such waivers. That bill, by prohibiting such waivers, implicitly acknowledged that the Secretary had such waiver authority. But my deeper concern is with this line of attack, that it is simply intended to impugn the most disadvantaged in our society for political gain. Finally, today's hearings also assail the Environmental Protection Agency's authority under the Clean Air Act to regulate carbon dioxide emissions by power plants. It's clear that Section 111D of the Act gives the EPA broad authority to address not just pollutants that were known at the time of the Act's passage, but also new problems as they arose. In fact, Congress intentionally gave the EPA the discretion as the expert agency to elaborate on these criteria and to resolve ambiguities in them. As protesters in front of the Capitol remind us, particularly during an election year, we should be using the committee's time to consider measures that provide real solutions. These include, for example, H.R. 885, the Voter Rights Amendment Act, which would help restore fundamental protections for voters. And we should address the flood of corporate money in our political system as legitimatized by the Supreme Court's Citizens United decision. Nevertheless, I look forward to hearing our witnesses today. I welcome them all, and I thank them for appearing. And I yield back, Mr. Chairman.
Nevertheless, I thank the gentleman, and without objection, other members' opening statements will be made part of the record. Let me now introduce our witnesses. Our first witness is Cleta Mitchell, a partner in the Washington, D.C. office of Foley and Lardner, LLP. And our second witness is Mr. David Bernstein, the George Mason University Foundation professor at the George Mason University School of Law. He's the author of the book Lawless, the Obama Administration's Unprecedented Assault on the Constitution and the Rule of Law. It was published in November of last year. And then our third witness is Emily Hammond, professor of law at George Washington University School of Law. Welcome. And our fourth and final witness is Andrew Grossman, a partner at the D.C. office of Baker and Hostetler. And we welcome you all here today, and we look forward to your testimony. Each of the witnesses' written statements will be entered into the record in its entirety. I ask that each witness summarize his or her testimony in 5 minutes or less. To help you stay within that time, there is a timing light in front of you. The light will switch from green to yellow, indicating you have 1 minute to conclude your testimony. When the light turns red, it indicates that the witness's 5 minutes have expired. Before I recognize the witnesses, it's a tradition of the task force that they be sworn in. Please stand to be sworn in. Thank you. Do you solemnly swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that the witnesses have answered in the affirmative. I now recognize our first witness, Ms. Mitchell, for her 5-minute testimony.
Thank you, Mr. Chairman, and members of the task force. Thank you for the opportunity to appear here today on this very important issue of executive branch overreach. And I think it's important, even though there are some specific agencies that are listed as the topics about which we're to discuss today. And I could spend the rest of the day detailing to you the experiences that I've had with and for my clients and their experiences with the IRS and the targeting. And just to put it in perspective, Congressman Cohen, I've been doing this for a long time. helping organizations receive tax-exempt status from the IRS. And in a nutshell, what happened beginning in 2009, that's the first client that I had that I began to realize something had changed in the fall of 2009. The IRS took what used to be a process that lasted 3 to 4 weeks and changed it without any notice to the public based on targeting and selection and really rounding up and branding of applicants, and turned it into a process that took 3 to 4 years and created burdensome, intrusive, multiple levels and layers of inquiries about every internal aspect of the organization's operations, such that it chilled the First Amendment rights of hundreds of citizen groups and tens of thousands of citizens in the United States. And I have attached to my testimony today, testimony which I provided to the House Oversight and Government Reform Committee in July of 2014, which conducted a hearing on how to keep it from happening again. And I'll just mention 3 of those items, but there are other suggestions in there. And Congress has enacted a couple of those things, but there's more that needs to be done. First, Congress should repeal the requirement that exempt organizations disclose their donor list to the government. It's a private schedule. It's not public. There's no public policy reason for citizens groups to have to turn over their donor lists to the federal government, to the IRS. And we would urge you to please repeal the Schedule B donor disclosure filing requirement. I would urge you to also enact legislation that creates a permanent protection so that the IRS is not, and any IRS employee is prohibited by law from utilizing the publicly filed campaign finance reports and published reports of donor information as a basis for targeting citizens and taxpayers for audit. That is, the Supreme Court has recognized the First Amendment rights of Americans to make contributions to organizations, candidates, and parties of their choice. And disclosure is required by law. The IRS should not be allowed to use that public disclosure as the basis for targeting people for audit or adverse tax activity. So we would urge Congress to make that clear in the statute that that is prohibited. And finally, I would urge the committee and the Congress to enact something that the Supreme Court said existed, but which courts throughout the country have resisted giving life to, and that is to provide an individual cause of action that citizens and taxpayers would have to pursue individual IRS employees and, frankly, other federal employees who violate the constitutional rights of taxpayers and citizens. The Supreme Court in the Bivens versus 6 unnamed federal narcotics agents, the Supreme Court recognized this cause of action, but the IRS and the government employees, the IRS employees in the cases that have been filed regarding the IRS targeting scandal have all said that such a right of action does not exist. We urge Congress to clarify and make clear that it does exist. And then I want to close with something that I think is important for Congress to recognize. This is not a partisan issue. This is the Article 1 role of Congress is very much at risk with executive branch overreach, not just in this administration, but going back for decades. And I have 5 recommendations that I would like Congress to consider doing. First, to reclaim its constitutional authority. First, I think Congress should abolish the House and Senate Appropriations Committees and reassign the funding responsibility to the committees of jurisdiction so that funding, oversight, and authorization are handled on an ongoing year-in, year-out basis by the committees of jurisdiction, rather than separating them such that oversight and authorizing is separated from funding. Secondly, I think that Congress should consider repealing all general legislative authority delegated to federal agencies, because what has happened over the last 40 years is that Congress has delegated its constitutional obligation for enacting legislation and sent that off to federal agencies and then wonders why it is that the federal agencies are acting like the Congress. So I would urge the Congress to repeal that general legislative authority that's been delegated and to provide that no regulations can be promulgated without prior congressional approval. I think you should abolish the Joint Committee on Taxation. We're never going to get tax reform or any changes that I've proposed until and unless you get rid of the Joint Committee on Taxation. I've included recommendations that also were in testimony a year ago, again before the House Committee on Oversight and Government Reform, on how FOIA needs to be redefined, the deliberative process, privilege needs to be eliminated, and frankly, I would recommend that Congress create within the GAO a FOIA watchdog division, and that all the funds that are now spent by agencies spending the taxpayers, the millions and millions of dollars, telling us things that may not even be true, and those funds be reallocated so that when citizens try to enforce their FOIA rights, that they actually get a proper response and get the documents that the law says they're entitled to have. And finally, I would urge Congress to repeal the Chevron deference doctrine that provides that when litigants appear before the courts of this land to try to hold a federal agency accountable, the court puts the thumb on the scale and gives preference and deference to the agencies. Until Congress does something about these principles that have evolved over the last 40 years, we are not going to see an end to executive overreach. Thank you.
Thank you, Ms. Mitchell. And now recognize Mr. Bernstein for his testimony.
Thank you, Mr. Chairman, members of the task force. Thank you for having me here for this hearing. As the chairman mentioned, I have a book about the Obama administration and what I perceive to be its lawlessness that I document there, but I want to emphasize that, as Ms. Mitchell said, the encroachment by the executive branch on the powers of the legislature and of the judiciary to some extent has been going on for a long time, and I'm afraid we're reaching a tipping point. And for those who think this is solely a partisan issue, I would suggest that you consider, when I discuss these issues today, how you would feel if a President Trump or a President Cruz exercised similar authority if and when they became president. So I'm going to focus on several examples today of how the Obama administration has not only violated the law, which is not that uncommon for the executive branch these days, but has done so in ways that really pose a threat to checks and balances and are meant to evade checks and balances. The administration has not only acted unilaterally without congressional assent, which is what has gotten most publicity, but in some cases, the ones I'm going to discuss today, has acted in ways that make it almost impossible for the judiciary to get involved and be the final check on the executive branch. So my first example involves new government regulations that are disguised as mere guidance, right? So all these executive branch agencies have all this power, and they're supposed to, Congress decided in 1940 that in order to enact regulations based on relatively broad or vague congressional legislation, they need to go through this notice and comment period, go through the Administrative Procedure Act, and publish formal regulations that are then subject to judicial review. But one way of evading that is to just say, well, we're not making regulations, we're just issuing guidance. So the example I have is that in 2011, the Department of Education, Office of Civil Rights, sent a Dear Colleague letter to universities around the country requiring the universities to change the procedures that they have for dealing with sexual assault on campus when people complain of sexual assault. They were required by this letter to lower the standard of proof to find an accused guilty, and also denying accused students of their due process rights, for example, by denying them the right to cross-examine their accusers. The letter purported to be an interpretation of the Title IX amendments of the Educational Act of 1972, but there's really no case citations in the letter, there's no formal legal analysis, it's just diktat. Now, when questioned about this, sometimes OCR says, well, this is just guidance, these aren't real regulations. However, Assistant Secretary of the OCR, Catherine Lehman, testified under oath before the Senate a couple of years ago, and she said that we expect the recipients of the letter, in other words, all universities that in any way take federal funds, to, quote, fully comply with OCR guidance, unquote. When the government expects full compliance with its pronouncements, it needs to go through the notice and comment process and create regulations subject to judicial review, and not just announce these rules in a letter that can't be reviewed by anybody. My second example of administration overreach is the use of TARP funds to bail out Chrysler and GM, and then to use the leverage this gave the government to essentially run the day-to-day operations of General Motors for a time. And the Supreme Court established a long time ago in Youngstown Sheet and Tube Company versus Sawyer in 1951 that economic emergency, even when there's a war going on, like the Korean War, does not give the president authority to act unilaterally in the absence of statutory authority. And the most famous opinion from that case by Justice Jackson has come to stand for the proposition that the president's power is lowest when Congress has specifically denied the president the authority to do something. So here's a bipartisan issue for you. It was the Bush administration in late 2008 that started this. In 2008, Congress, of course, passed TARP and said we want to give money to financial institutions. Oh, we want to give money to car companies, we decided too. The House voted yes, the Senate said no. The president went ahead and gave the money to the car companies anyway. The Obama administration came in, instead of withdrawing from doing this illegal action, instead gave even more money to the car companies and said, by the way, we have a deal for you. You can't refuse. We're going to tell you who your chairman's going to be, who your board of directors is going to be, which car models are going to continue, which dealerships are going to continue, and there was really no statutory authority whatsoever to do this. The third example of Obama administration overreach might actually be called underreach, the administration's refusal to enforce certain deadlines that are in the Affordable Care Act. And they've done so for basically political reasons. There were some rules that would have required people to get new insurance plans that didn't meet Obama because they didn't meet Obamacare requirements. The administration just said, oh, we're going to postpone that for a few years and ask the state insurance commissioners to do so as well. They also changed the employer mandate, the 50 to 100 people with 50 to 100 employees. They said you don't have to abide by that, and it was because elections were coming up. This was unpopular, and they didn't even try to give legal analysis. There was no memo, there was no legal analysis. There were just blog posts on the HHS website. Government by blog post, one of my former students and now professional colleagues calls it. That's happened even when the Republicans offered to pass legislation to achieve the same goal. President Obama said, oh, I don't want you to pass legislation. I want to do it myself. If you pass legislation, I'm going to veto it. So my testimony has gone through these three categories: informally regulating through guidance instead of formal regulations, exercising massive regulatory authority without legislation over GM in the name of combating economic emergency, and delaying implementation of duly enacted legislation for political reasons. And I fear that if this isn't checked, the whole system of checks and balances we have is at risk.
Thank you, Mr. Bernstein. The chair will now recognize Ms. Hammond for her testimony.
Thank you, Chairman King, Ranking Member Cohen, and distinguished members of the task force for the opportunity to testify today. I'd like to make a call for nonpartisan administrative law. And what I mean by that is this. We should want a system that permits agencies the flexibility that they need to exercise their expertise while providing numerous mechanisms to ensure that they operate within the bounds of their statutory mandates. There is room for political decision-making within those statutory bounds, and we should be very reluctant to tinker with administrative law for political purposes, because doing so risks a system that operates poorly regardless of which party heads the executive branch. Our Constitution envisions this kind of system. Congress, of course, may provide as much specificity as it wants in directing agencies how to carry out their work. But this institution simply can't draft statutory language for every new challenge that will arise in the future. So the Constitution permits the President some degree of discretion in executing and enforcing the laws passed by Congress. With respect to federal agencies, the President indeed exerts a great deal of control over their policymaking, but the agency's behavior is constrained in important ways. Consider the Administrative Procedure Act, the APA. At every major part of the APA is a purpose to balance the need for agency discretion with the imperative that they stay within their mandates. The APA's judicial review provisions are important for enforcing these expectations. Indeed, as I testified in this room last month, judicial review enables courts to police those jurisdictional boundaries set by Congress. They can guard against serious errors and incentivize agencies to engage in legitimizing behaviors before the fact, promoting fidelity to statute. Let me give two examples of how this system operates. The Supreme Court's decision in Massachusetts versus EPA illustrates the limits of presidential control and the strength of statutory boundaries. As you are no doubt aware, that case involved an agency action rejecting a rulemaking petition to regulate greenhouse gas emissions from new motor vehicles under the Clean Air Act. EPA denied the petition, and it relied for its explanation on various presidential policy preferences. the court held that EPA's reasoning was arbitrary and capricious because it did not relate to the statutory text. Notably, this judicial role in cabining executive discretion operates regardless of the particular political view at issue. This is illustrated by the recent decision Utility Air Resources, Regulatory Group versus EPA, in which the Supreme Court again had occasion to consider EPA's approach to regulating greenhouse gas emissions under the Clean Air Act, this time under a different presidential administration with different policy preferences. Once again, the court held in part that EPA had exceeded its statutory authority. As these examples show, agencies admittedly push the boundaries of their statutory authority, whether or not at the express direction of the executive. But courts police that. And even when judicial review is not available, our system provides a variety of mechanisms to monitor agency behavior. It's striking that the other agencies being discussed today and their actions are the subject of incredible amounts of external review. The FBI, the Department of Justice, the Government Accountability Office, the press, the public, and of course this institution have all participated in oversight and robust debate concerning these issues. It's easy to pick a few examples of big agency decisions to criticize, but I want to emphasize that agencies take thousands of actions every day that conform to good governance. The expectations of judicial review have been internalized into agency culture to such a large degree that they are often present even for unreviewable agency actions. Our system of administrative law has a vast array of built-in mechanisms to ensure that agencies conform to their statutory mandates. The best policy approach is to let those mechanisms operate as intended, enabling transparency, robust debate, and improving regulatory governance going forward. Thank you for the opportunity to testify, and I look forward to your questions.
Thank you for your testimony, Ms. Hammond. The chair would now recognize Mr. Grossman for his testimony.
Thank you, Mr. Chairman, Mr. Ranking Member, and members of the subcommittee. I'd like to address three questions today, if I could. The first, what is executive overreach? The second, why does it matter? And the third, what can we do about it? To begin with, what are we talking about here? Now, in a very general sense, when the executive asserts authority to make decisions of major economic and political significance that have not been authorized by Congress, in a certain constitutional sense, that may comprise executive overreach. Likewise, overreach may involve enacting new policies that Congress has not enacted or has even rejected, or it may involve refusing to faithfully execute the law that has in fact been legislated. Now, that's one set of overreach, and that's a sort of qualitative view of it. But overreaching is typically facilitated and accompanied by other abuses, including arbitrary enforcement policies to achieve political or policy ends, the use of guidance to set forth new legal requirements, and structuring actions in such a way as to evade or delay judicial review. Now, let me give two examples that take these general principles and perhaps make them a bit more concrete. The first is the Department of Health and Human Services 2012 guidance that requested states apply to the department to waive the work requirements that were the centerpiece of the 1996 Welfare Reform Act. That act in particular requires two things. First, it requires that states require a certain number of the able-bodied persons on their rolls to engage in work activities. And second, it requires that those work activities be particular work activities, not made-up work, not busy work, but specific things that actually look and feel and seem like work. The President asserted authority under Section 1115 of the Social Security Act. But that section actually specifically does not apply to the provision of the Welfare Reform Act that concerns the welfare work requirements. Indeed, that statute expressly conditions funding to the states for their welfare programs on adherence to the work requirements. The Section 1115 waiver authority applies only to other items concerning state plans, areas of state plans where states have discretion, where they can experiment, where they can do different things, where they get to make choices. The work requirements were not among those things. There are 3 or 4 different features of the statutory scheme that confirm that particular interpretation. The 2012 guidance addressed none of this. In fact, it barely provided any legal rationale whatsoever. Why? Well, the reason was that the administration recognized that there was basically no possibility that anybody could challenge this measure in court. The administration knew that this was a blatant attempt to circumvent Congress's command. it engaged in what appears to me to be unusually aggressive statutory interpretation. It blew up a very limited waiver authority to something that the waiver authority plainly does not contemplate or countenance. And then it did all of this with the expectation that it would be able to evade any kind of judicial review. And indeed, the thing that surprised me during this particular episode is that the administration's defenders in this particular action chiefly argued simply that nobody would ever be able to take the administration to court to prove their point. In other words, there was very little defense of this particular action on the merits. Likewise, the Clean Power Plan to regulate carbon dioxide emissions from existing power plants relies on an obscure, all but forgotten provision of the Clean Air Act to seize authority over electricity production across the nation. According to the administration, the provision allowing EPA to determine the, quote, best system of emission reduction applicable to a particular kind of source, in this case power plants, authorizes to require generation shifting. In other words, running some kinds of plants less or closing them in favor of other types of sources that are preferred by the EPA. Now, that abandons 30 years of consistent EPA interpretation of that statute, 30 years of judicial interpretation of that statute, and it clashes with plain statutory requirements, for example, that a particular standard be achievable by sources to which it's applicable. In short, it could provide a basis to shut down any plant, any source of emissions in the entire country in favor of some other thing that EPA might prefer. And that's exactly the kind of discretion that Congress sought to deny EPA due to the economic consequences that would be involved. Congress wanted to retain that authority for itself. Again, this has all of the hallmarks of overreach. It's a blatant attempt to circumvent Congress, which rejected the administration's plans to regulate greenhouse gas emissions. It's enormously aggressive statutory interpretation. And moreover, the administration attempted to rush the rule into force so as to evade judicial review. Well, it didn't work. The Supreme Court stayed the rule, recognizing that it was likely illegal. Why does any of this matter? Well, I don't think this is about partisan politics at all. It implicates the rights and the liberties of all Americans. The Constitution provides for separation of powers to protect individual liberty, and it provides for checks and balances to confine each branch of government to its proper place, and thereby enforce the separation of powers. The precedents that are set by this administration would provide a basis for future executives to carry out policies that could never pass Congress. In this way, departing from the constitutional design because it might be convenient today jeopardizes Americans' political freedoms and individual liberties over the long term. Now, finally, let me address what Congress can do about executive overreach. In my written testimony, I offer a number of different proposals that Congress should, to my mind, consider. Let me briefly address three of them here. The first, as Ms. Mitchell described, is to rethink judicial deference to agency interpretations of statutes and regulations. Doctrines like Chevron and Auer have facilitated overreaching across the board. In too many instances, the search for meaning in written law has been replaced with a hunt for ambiguities that might allow the agency to escape the legal confines of the law. Congress can and should rethink these doctrines. Second, Congress should act to ensure that judicial review is always available and as much as possible is effective. That may include automatically pausing certain agency actions so that agencies can't force compliance with legally questionable rules before courts have a chance to review their merits. And third, Congress should reconsider broad delegations of authority. At one time, Congress could reasonably expect that the executive branch would not seek to take advantage of unclear or ambiguous statutory language as a basis for launching broad policy initiatives. Those kinds of issues, it was well understood, would be left to Congress. But that time is long past, and the open-ended language remains in the books. Congress should take care to ensure that new laws reserve its policymaking authority and, as possible, should act to clarify older statutes. In conclusion, executive overreach is a serious problem, and the task force should be commended for its efforts to identify the scope of the problem as well as potential solutions. I thank the subcommittee for the opportunity to testify on these important issues.
Thank you, Mr. Grossman. I thank all the witnesses for your testimony. And we'll now proceed under the 5-minute rule with questions, and I'll begin by recognizing myself for 5 minutes. First, Mr. Grossman, the recommendations that you've discussed here consider the judicial review, and I wanted to pose this, that as I've watched our executive branch's overexuberance on regulatory regulations that are emerging, if we go to the courts and appeal to the courts when they've overreached, it looks to me like an administration can come and go before we can get resolution in the courts. And listening to Ms. Mitchell's testimony this morning, how do we deal with that?
Right. Well, I mean, there are certain ways to structure judicial review so as to avoid the kind of gamesmanship that has plagued agency actions in recent years. One example that Ms. Hammond noted was the Utility Air Regulatory Group decision. But I will note that the major rule that came after that really drew a lot of controversy was the so-called Utility Act rule, which was a major regulation of power plants that the administration rushed into force despite lots of opposition, not merely by power plant operators, but by grid regulators and the like, arguing that there should be a more gradual implementation period so as to reduce costs, so as to allow for judicial review, and so as to protect the integrity of our electrical grid. The administration turned a blind eye to all of that in its response, and as a result, by the time the Supreme Court ruled that that rule was illegal, it had already been in force, and basically everybody had complied. I think one thing Congress should look very
recognize that
seriously-
point. I'm just watching my clock tick down here. So, do you have knowledge of the drafting of the work requirement in the TANF regulations? I mean, it's my recollection that it was written as tight as possible with the idea that it would prevent a president from circumventing or waiving the work requirement. Would that be true? And is it possible to write something tight enough that perhaps the president would recognize that it's too tight for him to jump out of those boundaries?
Well, I think in this administration, it seems like almost anything's fair game. But if you take an honest and fair view of the statute, there simply is no waiving those particular work requirements. The waiver provision does not extend to them. It's not, the language simply isn't there.
We have to have an honest and fair view or we're caught up in forever litigation. I turn to Mr. Bernstein, and just thinking about your comments that had to do with the auto companies. And I recall a witness we had here from the state of Indiana testified, seated where Ms. Hammond is right now, and he testified that as the bankruptcy of Chrysler, as I recall, went before the court, that there was only one appraisal, the White House's appraisal, and let's see, there was only one proposal that went before the Chapter 11 court, and that there was only one bidder on the tail end of that, and in all cases, the appraisal, the Chapter 11 proposal, and the bidder on it were all the White House. That there was only one proposal in each one of those three cases, and I recall asking him, were there any I's crossed differently or any T's crossed differently as a result of the testimony before the court, and his answer was no. Is that a fair picture of the package that was offered by the White House that you described?
That's fair, and it's also the case that it was designed to benefit the oil workers union that supported the Democrats in the 2008 election and beyond, and to harm other stakeholders such as the Indiana Pension Fund that was probably represented by the person that you had here. The bankruptcy court just deferred to everything the administration did, said, well, almost everyone who was a bondholder agreed to it. The problem was the bondholders were all big financial institutions that were being threatened with criminal and civil prosecution for their role in the 2008 financial crisis, and they were given one of these deal you can't refuse choices. So the Supreme Court, though, upheld everything but vacated the lower court's actual legal findings and said this is not going to be precedent. It was too late. The companies already merged, so it was already moot by the time it got to the Supreme Court. So we don't know what the court would have said.
Would be nice to be in a business deal and have that kind of leverage. Thank you. And I turn to Ms. Mitchell, and I appreciate your recommendations here, clear, concise, compact. I wanted to propose in return to one of your proposals here, a bill called, it's H.R. 2778, the Sunset Act. It's a bill that I offered several cycles ago and probably need to push harder in the next administration. What it does is it sunsets all regulations, phased in 10% a year for 10 years, so the agencies are required to offer up all of their regulations to Congress, requiring an affirmative vote for them to have the force and effect of law. And it says that any new regulation, regardless of its value, has to have the affirmative vote of Congress, and it also sunsets in the end of 10 years. Would something that I've described here, would that conform to one of your proposals?
It's certainly a step in the right direction. I think that the only way that Congress is going to restore its role as the Article I branch of government is for Congress to take some serious and seemingly radical positions. I mean, I'm pleased to hear Ms. Hammond describe the Administrative Procedures Act and this nirvana that could exist. It's just that that isn't reality. I'll give you an example with the IRS. It's one of the things I've learned, having dealt with them now for 7 years on the scandal and its ongoing tentacles. When the IRS unveiled its proposed regulations to basically enshrined the discriminatory activities that they had undertaken with the application process and proposed new regulations that they had developed in secret, off-plan, no notice. They were sprung on the citizenry on Black Friday, the day after Thanksgiving of 2013. One of the things that I've learned since then is that the IRS has taken the position in judicial proceedings that the Administrative Procedures Act is not applicable to IRS regulations. The IRS regulations are not subject to the Regulatory Flexibility Act. They're not subject to the Paperwork Reduction Act, and that it can basically do whatever it wants. Now, if Congress is going to sit by and let the IRS continue to take that position, that's a pretty frightening prospect. And I think that Congress has to take dramatic steps to curb specific excesses in agencies and to do the kind of general repeal of the unfettered regulatory power that has been, in my view, unconstitutionally delegated to the executives.
Thank you, Ms. Mitchell. Of course, I would just abolish them and simplify this considerably. Chair would recognize the ranking member from the state of Tennessee.
Thank you, Mr. Chair. You know, I agree that there's executive overreach. There's been by all executives. I think, you know, power is taken, not given, is a Machiavelli rule that continues and will live forever, I guess. We had it when Bush was president. The IRS, Nixon's the champion. He's #1 with the enemies list. It was awful. And Ms. Mitchell, you had some good comments, and I understand them. But you talked about all these groups that had Patriot in their names. There were other groups that were looked at too, and I've got some information because I asked. You know, there were some of these groups that were more Democratic type groups. Progress was in their names, and so they got picked. Progress Missouri and I think Progress Texas, and there were California group too was set up primarily for the benefit of a political party, and they were looked into. Merge America, and so, you know, are you familiar with those cases?
Yes, sir, I am.
Don't you think it would have been a little better for you to have mentioned those cases in your testimony as well, as to show that the IRS, it was an IRS problem. It was not a political assault on Tea Party folk, but it was an effort by some people that was bad policy to go after a bunch of different people, some of whom were more considered liberal. And if I think we approach it that way, I think it'd be better to deal with the issue than just pick out the one groups.
Well, Congressman, that would be fine, except that that is not a correct characterization of what happened. And I can give you a specific example with Progress Texas. If you look at the data, which the Committee on Oversight and Government Reform has compiled, and which the testimony of the Treasury Inspector General for Tax Administration specifically provided to the House Ways and Means Committee, you will find that those assertions in that New York Times article about how the IRS was an equal opportunity discriminator, turns out that that is not exactly correct. And I'll give you just the example of Progress Texas. Progress Texas showed up on a list. There were, I think, 85 groups in September of 2011. Progress Texas showed up on that list along with, as one of 3 or 4 liberal-sounding groups. The commentary about Progress Texas said that it appeared that they had anti-Rick Perry propaganda on their website. Now, contrast that with King Street Patriots, one of my clients, or Tea Party Patriots, one of my clients, where the commentary would say by their names appeared to have anti-Obama propaganda. That was September or November, sometime in that time period, in the fall of 2011. In June of 2012, Progress Texas got its 501c4 letter of exempt status. Tea Party Patriots did not get its C4 status until February 29th of 2014, the day that its president testified before the House Committee on Oversight and Government Reform. And King Street Patriots didn't get its exempt status until the fall of 2014. So the disparate treatment is documented. And anyone who thinks that's not true just hasn't studied the record. I'm sorry.
Well, but the fact is, what is true, and we have studied the record, is groups with the name Progress were looked at as well. And they did not just automatically get their exemption. And groups that were liberal got it, same kind of examination. And
No,
I don't
they
know about you,
didn't.
I don't know about your situation. Maybe they hired you early, and maybe the other groups didn't, and because you were hired and were so thorough that they had a little bit more difficulty and took a little more time, or maybe they had more people or didn't respond as quickly. I don't know. But the fact is the IRS was bipartisan in the way they did it. They weren't right with either side, and the IRS corrected it, and there were no criminal investigations and no reason for a criminal investigation because there was no probable cause.
Well, I
Ms.
would-
Hammond, I would like to ask you about your proposal to deal with the Administrative Procedures Act. How do you think we could do that?
I'm sorry, sir.
You had a suggestion we should change the law to make it.
In fact, I do not suggest that we should change the law. I don't agree that the APA is nirvana. It is not perfect. It is functional. And what it attempts to do is strike this balance that I was discussing by trying to ensure that agencies do have the flexibility to exercise their expertise, but that we ensure that they remain faithful to their statutory mandates. And so I don't propose that we change the APA in any way, not because I think it's perfect, but because I think it's pretty good.
And are you familiar with Progress Texas, Emerge America, and some of the groups that were considered more liberal that were also given extra scrutiny by the IRS?
Yes, it is my understanding that some of those groups were targeted as well.
Thank you very much. I yield back the balance of my time.
The gentleman is back. The chair will now recognize the gentleman from Texas, Mr. Gohmert.
Thank you, Mr. Chairman. Thank the witnesses that are here. So much to correct with so little time. Colleague on the other side of the aisle said this was political theater, said an effort to brand president illegitimate. That struck a memory nerve. And I recall when Bill Posey filed a bill, and I thought it was a good bill. It was a good bill, just over 2 pages. And it was going to require that in future years, future elections, had nothing to do with 2008, that since there was no enabling statute for the constitutional requirements of age and being a natural-born citizen, it would provide enabling statute to do that and require the parties to resolve in advance whether somebody meets those 2 constitutional requirements. I thought it was a great idea, especially since the Washington Post and New York Times had questioned John McCain's viability to meet those. I have never, ever said the president was not a natural-born citizen. I've been branded a birther because I signed on to Bill Posey's bill. But through that, reporter after reporter after reporter asked, so why are you now trying to delegitimize the president and get him thrown out of office? And one of the best reporters here in town, I said, have you read the bill? She said, no, but I got my information from the highest level of the White House. I got a memo. It says you are the newest guy trying to delegitimize the president, get him thrown out of office. I said, read the bill, and if you have questions, then ask me. She read the bill. Next time I saw her, she said, that was nothing like the White House said it was. I said, yeah, it's a good bill. It was a good bill then. It's a good bill now. Even with Obama going out of office, it'd be a good bill. But that word, illegitimate, delegitimize, it is an effort to brand legitimate efforts to fix things that are wrong. Now, the Obama administration, despite the comments that everything's fine, this is no different, all the administrations are the same, 23 times have been told that you've gone too far. And it's unprecedented. Nobody's ever come close to having 11 unanimous Supreme Court decisions, including the extreme liberals, saying, Obama administration, you have gone too far. So as far as being illegitimate, this is legitimate stuff. And as far as the Justice Department finding that the IRS did nothing wrong, they said, well, now, we found mismanagement, uncovered substantial evidence, mismanagement, poor judgment, institutional inertia. On over, they say, now, although Ms. Lerner exercised poor judgment in using her IRS email account to exchange personal messages that reflected her political views, yeah, that was inconvenient because it showed that she was acting in accordance with her political positions. There was plenty of evidence, just like this administration after both a United States District Court and the Fifth Circuit Court of Appeals said there is substantial evidence to find that these other Muslim organizations are acting in conspiracy with the Holy Land Foundation that was found guilty of supporting terrorism. This administration came back and says, we find no evidence, after courts had already said there's plenty of evidence here. We're not striking their names. So it is really unfair to say that this administration finds no evidence and try to relate to that, to there being no evidence. Now, I appreciated very much the recommendations, Ms. Mitchell. Those were terrific. And I'm sorry, I always did well on national testing because I ask questions when I don't know. And I'm curious, what is the Associate Dean for Public Engagement? Is there a Dean of Public Engagement that's over you? What does public engagement do?
There is a dean of the law school, that's Dean Blake Morant.
But there's no Dean of Public
That's correct.
Engagement. So the Associate Dean is the top Dean of Public Engagement.
That's correct, but underneath the full dean of the law school.
Gotcha. Okay, thank you. With regard to the TARP overreach, I got to say, that was such a horrible bill. It gave them all kinds of ability. It's why I was so opposed to it. But I would just like to encourage each of you, because our time's so limited here. Ms. Mitchell, you've given great recommendations. I would encourage each of you. I know Professor Hammond doesn't see any needs, but we got to fix this system. You've made some great recommendations. Any others that you could recommend things to do, please recommend them. We got to do these things. Thank you.
The gentleman from Texas yields back. The chair would now recognize the gentleman from Florida, Mr. Deutsch.
Thank you very much, Mr. Chairman. First, thanks to the witnesses for being here. Ms. Mitchell, just one question. Since we're using the admittedly flawed criteria that the IRS used, how many organizations were ultimately denied their tax-exempt status as social welfare organizations for compliance with 501c4?
Congressman, you know, that is part of what the Sixth Circuit excoriated the IRS about in that opinion.
I don't think any.
Ago.
Right,
I don't think we know yet.
So,
I don't think we know yet.
I appreciate that. So just given that, I just would like to make a few observations. We find ourselves here during what has been much publicized as the GOP Tax Week.
Thank you very much.
And I suppose during Tax Week we're here to commemorate the 150 million tax filings that flooded into the IRS, 5 million coming in just yesterday after the deadline passed. The majority no doubt thinks the best way to curry favor with the American public is to blame the IRS. I don't buy it, frankly. I would point out that Congress gets the money to fund this hearing from IRS tax revenue, that we earn our salaries as members of Congress thanks to the IRS collecting tax revenue. And so while the IRS absolutely and legitimately needs reform, the majority refuses to acknowledge what the agency does right, how to fix what actually needs to be fixing, and instead looks to generate headlines this week by blaming the IRS for seemingly everything wrong with the government. So here's the question. Were social welfare groups handled inappropriately at the IRS? Yes. But is that the real scandal, Mr. Chairman? The real scandal, I would suggest, is the fact that political spending by so-called social welfare groups is exempted from taxation and is subsidized by the American people. These groups are some of the biggest players in politics. And my friends on the other side of the aisle should not be complicit in their attempt to hide their donors or agendas behind some hollow outrage at the IRS. The poor handling of tax-exempt applications at the IRS was a direct result of the Supreme Court's obliterating our campaign finance system in Citizens United. After that decision, thousands of new applications flooded the IRS. These groups were specifically created to skirt disclosure requirements and contribution limits. That's the scandal that we ought to be focused on. Consider that just after Citizens United came down, thousands of new applications came in for social welfare tax-exempt status, a 92% increase from 2009, before Citizens United, to 2012. Many of these groups were created at the direction of sophisticated, well-connected, and well-funded Beltway campaign funders who went to work to create all kinds of complicated webs of tax-exempt groups to funnel money, unlimited contributions from one organization to another. Why? Why was that done? What is the scandal here? It's to hide the identity of donors, to make it seem as though campaign season ads are speaking for the people, when they're really speaking for the wealthy individuals and corporations that fund these super PACs that so often we don't even know about because of these 501c4s, to obscure connections to corporations that don't have the best interest of the people at heart, corporations who want to stop clean energy requirements, corporations who want to prevent gun efforts to stem the tide of gun violence, corporations who want to protect subsidies, tax breaks, and loopholes. And many of these social welfare organizations are nothing more than a post office box in Alexandria, Mr. Chairman. Why do we have to continue to waste the resources of this Congress to conduct this hearing after internal and external IRS reviews, FBI and Department of Justice investigations, a partisan contempt proceeding, and multiple investigations by House committees, including hundreds of interviews and hundreds of thousands of pages of documents collected? We find ourselves just where we started. The real scandal is the scandal this Congress is doing nothing about, and it's the overwhelming influence of money in politics. The true scandal is that Congress refuses to accept responsibility for putting the IRS in the position of evaluating tax-free political activity. The actual scandal is that Congress refuses that the American people shouldn't be forced to subsidize the political activities of sham groups. The scandal that I'm most ashamed of, though, Mr. Chairman, is that this House of Representatives will do nothing except hold these show trials. Today's hearing won't do a thing to stop a system that protects big money in politics, but it will help to continue the dominance of the wealthy few over the will of the people in our American democracy. That, Mr. Chairman, is the scandal that we ought to be focused on, and I hope one day we will. And with that, I yield back.
Chair thanks the gentleman from Florida, and now recognize the gentleman from Ohio, Mr. Jordan.
Thank you, Mr. Chairman. The gentleman from Florida mentioned the real scandal. Here's the real scandal. The IRS systematically targeted conservatives for exercising their First Amendment political speech rights. They did it in a systematic way, and they did it for a sustained period of time. They get caught. Lois Lerner gets caught, and she does what all kinds of people do when they get caught with their hand in the cookie jar. She lies about it. Isn't it true, Ms. Mitchell? She went to a Bar Association speech May 10th, 2013, planted a question from one of her friends, and said, wasn't me, it wasn't us, it was folks in Cincinnati. Isn't that true?
That's true, but it wasn't true.
Right, exactly.
She said it, but it wasn't
She said
true.
it, but it wasn't true. The fact show was all in Washington. So she lies, and then when she gets caught lying, she does what happens sometimes. She's brought this committee room at that same table you're all sitting there, and she takes the fifth. So now here's what happened. The central figure lies when the story first breaks. Then she takes the fifth. Now this sort of, any criminal investigation, any congressional investigation, there's a premium on getting the documents, information, emails, communications, all the stuff that went on. But when you have the central figure taking the fifth, it really emphasizes the need for the documents. So Mr. Koskinen is brought in. The president says he's the fixer. He's the professional guy brought in to fix this system and clean up the IRS. And under his watch, I think he breached every duty he had. Would you say, Ms. Mitchell, that he had a duty to preserve the documents that were there relevant to the congressional and criminal investigations that were going on?
He absolutely did. They were under subpoena from the House Committee on Oversight and Government Reform in August of 2013, and they weren't produced. The subpoena was reissued in February of 2014, and he
Two subpoenas.
two subpoenas, and not only that, but there was ongoing litigation with respect to as early as
Some of
May
your
of
clients.
2013, and my clients, and the Z Street case, which
Yep.
has been filed in 2010,
Two-
and involved the very same factors and
Two
emails
subpoenas.
and documents.
Two subpoenas. 3 preservation orders. The IRS themselves, they sent a preservation order to themselves. They said preserve all documents. So Mr. Koskinen and his IRS had a duty to preserve all the documents. They had a duty to produce them to the committee because we subpoenaed them. And they had a duty to inform us if they couldn't preserve them or didn't preserve them and couldn't produce them. And so all 3 of those duties were breached when they allowed 400 backup tapes to be destroyed. Would you agree, Ms. Mitchell?
I agree, and I think that for that reason alone, but certainly for many others, I think that Commissioner Koskinen has lied to the Congress repeatedly, and he should be impeached and removed from office.
I didn't even got to that, but you're exactly right. You're exactly right. Duty to preserve, they failed that. Duty to produce documents, they failed that. Duty to inform us in a time. He knew that problems with Ms. Lerner's email or with her server and her emails, he knew about that and waited 4 months to tell us. He waited 4 months to tell us that some of the backup tapes had been destroyed. 400 backup tapes destroyed, potentially 24,000 emails, and he comes and testifies and says nothing. And then he said, oh, when it came to the backup tapes in the later testimony, that they were all destroyed. Some of them weren't. Some of them were. So he had a duty to testify accurately, duty to correct the record. And it seems to me when we're talking about executive overreach, one of the things the legislative branch can do is impeach this guy. I mean, that's the record. Now, we can add to it. Let me do one other, if I could, Mr. Chairman, one other area that. You familiar with Stingray technology, Ms. Mitchell?
A little bit. I'm conversant.
So Stingray technology, my understanding is this is the capability that certain law enforcement and, in this case, the Internal Revenue Service has to bring this technology into an area and find geolocation technology. What happens is this device mimics a cell phone tower, and all the cell phone numbers in that area they can find out where you're at, your number, and collect. It's a net. It's not a fishing line. It's a fishing net. Last week, testimony in this committee, we learned that the IRS has employed this technology 37 times, and each time did it without a probable cause warrant. You think that's appropriate for the agency with the track record we now know that they have relative to conservative groups is employing this kind of technology without a probable cause warrant?
Absolutely not, and that's why I think that that Congress needs to establish an individual cause of action to be for individuals whose, in the cases that I've been talking about, where First Amendment rights were violated. If your Fourth Amendment rights are being violated by the IRS and by individual IRS agents and employees, you ought to have the ability to file a lawsuit and get damages. We have to find ways to hold the individual people accountable for violating the constitutional rights of the American people. And if Congress doesn't do that, we're never going to get control of them.
I appreciate it, Mr. Chairman. I thought I was, but I see my time has expired. Thank you.
Gentleman returns to time, and the chair would now recognize the gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. I am going to barely resist the temptation of asking questions of law professors, other than to just note, Professor Hammond, at some point I would like to discuss with you in Ray Aiken County, which is a case on prosecutorial discretion, as you probably know better than I do, because I am somewhat vexed as to whether or not there are any limits on prosecutorial discretion. Some of my colleagues on the other side don't seem to think there are. And you also mentioned oversight, and at some point I'd like to discuss with you when Congress sends a subpoena and that subpoena is not honored, or when Congress seeks to do oversight and the executive branch does not cooperate, what tools we have. And the order in which you would use those tools. But I am going to save all of that for a later date because my attorney from Ohio, Jimmy Jordan, is here, and I would like to give the remainder of my time to my attorney, Mr. Jordan.
Well, I appreciate the gentleman yielding. And let me go to this, and let me go to Mr. Grossman here. Are you familiar with the tax gap that exists at the Internal Revenue Service? In other words, the difference between what they're supposed to be collecting for the federal treasury and what they actually do collect?
I'm afraid I'm not.
Anyone familiar with how much that is? $385 billion, according to the GAO study that was released in the last 2 weeks. $385 billion that the this is the fundamental mission of the Internal Revenue Service, is actually to collect the tax revenue due the federal treasury. That's what their job is, and they're failing to the tune of $385 billion a year. You think about our deficit this year, I think it's $500 billion. So I mean, this is a huge amount of money. So a $385 billion tax gap. The GAO also recommended that the Internal Revenue Service employ 112 recommendations, 112 specific things the IRS can do to help them comply in accomplishing their fundamental mission, collecting revenue for the Treasury to fund the things and the services and things that we have in our government. And to date, the IRS has only implemented 62. So less than half of the recommendations to help accomplish their fundamental mission they've actually put into practice. And it sort of begs the obvious question. You got time to harass conservative groups, ask them all kinds of intrusive questions, privacy-violating questions, infringe on, this is something I think gets lost in this debate too. Remember what the underlying offense was here. They were going after people's most cherished right, your right under the First Amendment to speak out against the policies of your government. Fundamental and central to who we are as a country. So the very agency that has a $385 billion tax gap can't even do half of the recommendations GAO says you should do to accomplish your fundamental mission, has time to target people for exercising their First Amendment liberties. Mr. Bernstein, do you want to comment on any of that? I got a little speech there. I didn't have a question, but I'll let you comment. And I got one other question I want to ask you. Go ahead.
I could comment briefly because I do discuss this in my book. They were under a lot of pressure also. I don't know that much about Ms. Lerner's own political views except what I've seen in the media, but they had letters from various senators, from congressmen. There was political pressure coming from the White House that after Citizens United, we think this stuff is going to benefit Republicans, and we need to have you guys crack down on it somehow.
Yeah, right. Ms. Lerner, she gives this now somewhat famous speech at Duke University where she says, everyone's after us to fix it now. She gave this speech in the fall of 2010. Fix it now meant before the election. The pressure she was getting and letters she was receiving from all kinds of Democrats in the Congress. So she felt some obligation to try to address the situation now. You know, do you think, back to the Stingray technology, Ms. Hammond, do you think any of the 112 recommendations made by GAO to help the IRS accomplish their mission, do you happen to know if any of those 112 included the IRS buying and employing Stingray technology? Do you know?
I don't know.
Did anyone know? Mr. Grossman, do you know? Mr. Bernstein, do you know? One of the recommendations was to buy this Stingray technology and use it on citizens to accomplish the fundamental mission. Ms. Mitchell?
I'm assuming the GAO did not instruct the IRS to go buy Stingray technology.
You would be absolutely right. You can move to the front of the line. I mean, think about that. 112 recommendations. The IRS has one Stingray. They're in the process of buying another. 112 recommendations to help you actually do what you're supposed to do, collect revenue for the Treasury. They can't implement even half, but they're buying a second Stingray. They're going to potentially use that and infringe on American citizens' Fourth Amendment liberties. This is the IRS that John Koskinen is commissioner of. This is the IRS that allowed documents to be destroyed, violating people's First Amendment liberties when the targeting took place, and now using our tax revenue, the limited amount that they're collecting, or actually not limited, a lot of money they're collecting, but not the full amount, to buy technology to infringe on our Fourth Amendment liberties. Again, underscoring why Mr. Koskinen should have articles of impeachment moved forward against him. With that, I yield back, Mr. Chairman.
The gentleman from Ohio yields back to the gentleman from South Carolina, who yields the balance of his time, and the chair now recognizes Mr. Issa, California.
Thank you, Mr. Chairman, and I apologize that wounded warriors got between us and part of this. Ms. Mitchell, it's good to see you. As always, you did a good job of listing more things than I could write down. And they were all good, but I want to ask you sort of I don't want to be rhetorical. I want to be as straightforward in the question. If it's been asked already, I want to apologize. But as you know, the Ways and Means Committee referred a criminal referral to the Department of Justice against Lois Lerner, which said, and I'll paraphrase as close as I can, 18 U.S.C., the U.S. Attorney for the District of Columbia shall present to the grand jury these accusations. They didn't do that. If that is the case, which it is, what would you suggest in the way of reforms? If we have the IRS with an individual adjudicated by the Committee of Jurisdiction, which was not my committee, it was Ways and Means that did it, based on all of our investigations, that in fact she criminally conspired to withhold people's rights and did so in a number of areas and then lied about it, which the lie was actually part of it. What do we do if in fact a congressional referral that has the weight of law that ordered the U.S. Attorney to do something and the U.S. Attorney didn't do it? Are we to impeach the U.S. Attorney? Should we get the U.S. Attorney disbarred? It's still out there. The fact is Loretta Lynch could do it today, but if I see her in the hallway, I'm not going to ask her when. So perhaps you could opine on that, because that, to me, all your suggestions may be for naught if government refuses to do that which is already on the books.
Well, Congressman, as you know, this Department of Justice has been documented as being the most politicized Department of Justice in American history. And not only did the Department of Justice fail to proceed with a criminal referral from House Ways and Means with regard to Ms. Lerner, the U.S. Attorney for the District of Columbia failed to and refused to proceed to enforce the contempt citation that the House enacted for contempt of the House. And the thing that I always come back to as well is the President of the United States went on national television in prime time on May 14th of 2013, right after the IRS scandal broke and the Tickler report was issued, and he said, I'm mad too, and I'm directing the Eric Holder and the Justice Department to conduct a complete, full investigation. And the Justice Department interviewed Lois Lerner for 12 hours. She talked to them. They had the ability to put her in jail. They talked to IRS employees and agents, but to my knowledge, they didn't talk to any of the victims of the targeting. And then they concluded that there was nothing to pursue. I mean, it was a sham investigation.
Well, let me
so
follow.
The Department of Justice that's a huge problem.
Well, this committee, as broadly, has the authority to change the Department of Justice in pretty profound ways if we choose. Let me ask a question, and I'll open it up to all of you. In light of the fact that before this committee, in a question that I asked former Attorney General Eric Holder, his answer, and I have to be honest, I don't fully remember the question, but I can tell you the answer. He told me he wore two hats. One is the highest law enforcement officer in the land. The other, quite evidently, is a political appointee to the president. And that includes consulting to the president, even though the president has his own lawyers, and it includes, in fact, strategizing with the president over politics. So, and we've now learned that the Attorney General, in his emails, in pretty good detail, led an attempt to withhold from the Oversight Committee, in the Fast and Furious case, specific discovery. They planned what not to give and when not to give. So I'm going to ask you all a question I'd like you to opine on now and in writing, if you would. Isn't it time for this committee to consider depoliticizing the Attorney General's position? The FBI director has a single 10-year term where he's put up, he's confirmed, and in fact he does not serve in the ordinary pleasure of the president. Should this committee consider depoliticizing the Attorney General, taking it out of being dual-hatted? The president can have all the advisors and political people he wants, but make once and for all, in a post-Nixon, post-Obama period, make the Attorney General's position as nonpartisan as we can by making it a term appointment and not, in fact, a pure pleasure of the president. And go right down the aisle.
Well, Congressman, I've thought about this a lot, actually, but I would tell you that in my experience, in my lifetime, I don't believe there's any such thing as depoliticizing something. The IRS has 90,000 employees. Only 2 of them are political, appointed by the president. One for a set term, and one, the chief counsel, serves at the pleasure of the president. All the rest are career employees.
I don't want to disagree with you because you're very good, but when we looked at the embeds, some of whom were working for Mr. Cummings on the oversight staff and had been at the IRS for the previous years, there are a lot more political appointees than are official. But if I can go down the aisle for each of you, just to get your view on.
Can I just say this one thing? Just because they're supposed to be non-political doesn't mean they are. We saw it with the IRS.
I have no doubt that even the FBI is not what
Justice
we would
Department.
hope it to be, but I'd like to see, is this a direction we should go to eliminate, if you will, the dual hat that the Attorney General spoke of here? Please.
I think that's a very interesting proposal. I think it might pose some constitutional problems to have an executive officer who's not accountable to the president. We do have such officers under modern.
It is statutorily done in other areas.
It is statutorily done, but from an originalist point of view or from a proper separation of powers point of view, I'm not sure that I could defend it. There might be some way of splitting some of the Attorney General's duties with the judicial branch, because there are judicial functions that are part of the judicial, that are part of that could possibly be delegated there. And judiciary is allowed to appoint certain people, like with certain kinds of special prosecutors and whatnot. So there might be some room to try to split some of the responsibilities.
Briefly, Ms. Hammond.
I do believe that there would be separation of powers problems with changing the way these people would be removed, and I agree with Ms. Mitchell. I don't think that it's possible to depoliticize in that kind of way.
Look, the FCC and the SEC obviously have their examples, but and I'll agree that they're not completely depoliticized. Mr. Grossman.
And I would tend to agree with Professor Bernstein that would raise serious constitutional questions. But that said, I think the underlying premise of the idea, the frustration at the lack of accountability and oversight that's been possible in this administration, is something that can be addressed and should be addressed in a variety of different ways.
Thank you, Mr. Chairman. Thanks for your indulgence.
Gentleman from California yields back, and the chair would now recognize the chairman of the full committee, Mr. Goodlatte of Virginia.
Thank you, Mr. Chairman, and thank you to all for your testimony today. Mr. Bernstein, can you describe this administration's abuse of power in ways that hurt religious liberty?
Sure. Well, I think the most outrageous example of the administration's abuse of religious liberty, which really didn't get that much attention, is that every court in the United States that had ever reached the issue said that churches and other religious organizations have a right to choose their ministers, have a right to choose the people who serve them in a religious function. And it's a First Amendment right under both the Establishment Clause and the Free Exercise Clause. Every single court. There was a case that came before the Supreme Court in 2011, and the only issue that was in the lower courts was, does this particular teacher at a religious school qualify as a minister under the broad definition of minister for the ministerial exemption or not? Shockingly, when the case actually reached oral argument at the Supreme Court, this was not in the briefs even, the counsel for the Justice Department actually argued that there is no ministerial exception, that the government could, in fact, tell religious organizations who their ministers, rabbis, priests, imams, or what have you could be, with the only possibility of defense that you have a First Amendment expressive association defense under Boy Scouts of America versus Dale. But the people in this particular administration would have been against the decision in Dale. It was 5-4, and we know the court's in the balance now. So if Dale gets reversed, then you have no possibility of religious freedom. So that was really a shocking argument. In fact, Justice Kagan said, "Are you really arguing that? Like, that's shocking, even to her." And it's really an extreme view that we associate even the legal academy, which is very left-wing, with sort of the extreme left-wing fringe of the legal academy. And if the court had bought that, it would have been a really serious threat to religious liberty. Fortunately, 9-0, the court said absolutely not.
Very fortunately. Mr. Grossman, can you explain in more detail the problem caused when a regulatory action is challenged in court but is allowed to remain in effect for years until a final judgment on the regulation is reached by the courts?
Sure. Well, in many instances, of course, parties do seek to stay regulations, but the standard to obtain a stay is very, very high. And in many instances, the cards that you need, the information you need, the facts that you would need to obtain a stay are frequently things that are in the position of the agency, which, of course, has no interest in seeing its hard-fought rule put to the side while litigation continues. And so what this means as a practical matter is that in almost every instance, an agency can come forward with a legally aggressive, perhaps legally indefensible rule that imposes billions or tens of billions of dollars worth of costs, and they can, in fact, through sheer force, will it into being, irrespective of whether or not it is ultimately wound up being struck down by the courts, as the Utility Act rule was by the Supreme Court.
And this was taking an old law and rewriting the regulations without ever consulting the Congress, or in fact failing to get the Congress to take the action that the administration thought should be taken, and then going ahead and doing this, and the end result is that after years of litigation and the administration losing, they've actually really won because all the changes have already been made.
That's exactly right, and in that sense, it short-circuits the normal judicial process and short-circuits what we all think of as the rule of law. When somebody has to comply with the law and does so at enormous expense, in a sort of one-way fashion. In other words, they might retire a facility they own, they might bear some unusually large costs, they might suffer in some sense. That can't be undone. It can't really be fixed, and as a practical matter, it isn't. And it seems to me that that's simply contrary to the way that everybody understands that the rule of law ought to work, which is that you shouldn't have to comply with unlawful commands.
And what is the solution to that?
Well, I think there are two things. In a narrow sense, Congress certainly could prescribe, particularly in certain areas, that in certain circumstances, a stay is appropriate for rules when they raise certain types of issues or when they're challenged in certain kinds of ways. Look, there are a lot of parameters to do it, but I think a lot of that harm could be ameliorated. But the second thing is there needs to be a change in the relationship at this point between the executive branch and the legislative. The executive branch needs to be much more solicitous of what it is that Congress has actually legislated. We don't want people in the executive branch being aggressive and inventing new authorities that this body never intended.
Now that sounds very attractive to many of us here on the dais. How do we accomplish that?
Well, gosh, that's a serious question. My testimony does, my written testimony, that is, does suggest a few different ways of accomplishing that. And I think one of them would be looking at the deference canons that are applied by the courts in determining whether or not it is that agencies are following the law or not. As I testified and as I've explained with numerous examples, the search for meaning has largely been replaced with a search for escape hatches in the law. In other words, the executive looks, where is there an ambiguous word that I can use to do whatever it is that I would like? If courts got less into the business of rubber stamping that kind of reasoning and more in the business of scrutinizing whether actions comply with the law, I think you would see a different relationship between the branches.
Agreed. Thank you very much, Mr. Chairman.
I thank you, Mr. Chairman. The chair now recognizes the gentleman from Texas, Judge Poe.
I thank the gentleman. Thank you all for being here. Ms. Mitchell, it's good to see you again. I want to follow up on Mr. Ice's comments about abuse of power with the administration bureaucrats. It's been a long time ago, but House Representatives held Eric Holder, the Attorney General of the United States, the chief law enforcement officer in the U.S., in contempt of Congress for hiding information. It's been 4 years later. Not much has been said about it. But last week, 2 weeks ago, federal judge, Ms. Jackson, I believe, federal judge Jackson, ruled that, hey, the administration's got to turn over those emails to Congress. And the whole thing now has kind of gone away. Indicative of, when this happened, from the other side, we heard this hue and cry about, this is so awful about holding the Attorney General in contempt. But he got his day in court and he lost. The Attorney General was wrong in not turning that information over to Congress, even though it took 4 years to uphold what Congress did. Abuse of power, as I see it. Let's narrow it down to the IRS. Federal judge, I don't know this guy, David Centelli, last week said, quote, "It's hard to find the IRS to be an agency we can trust." Well, no kidding. Federal judge has got it right. We can't trust them. You talk to taxpayers, non-taxpayers out there in the fruited plain about the IRS, they don't say nice things about the IRS. And the bottom line is they don't trust the IRS. They feel like the IRS uses its authority to go out and use it for political persecution of individuals, one of which was your client, Catherine Engelbrecht. Now, I know you have attorney-client privilege, and I don't want to interfere with that, but it's been testified before this committee that the King Street Patriots, Catherine Engelbrecht's organization, that true the vote. That's all they want to do is have honest voting. Starting in 2010, had 6 visits by the FBI, 1 visit by ATF to her organization, 1 visit by the Texas Environmental Quality Agency, 1 visit by ATF. In some of those visits, the FBI was accompanied by people from Homeland Security, Harris County Sheriff's Office Terrorism Task Force. The FBI or the IRS wanted to know who attended these meetings, wanted to know where Catherine was going to make speeches, wanted to know who was in the audience when Catherine Engelbrecht made speeches, and wanted to know what her speech was about and what her future speeches were about. And it was all persecution of this organization by the IRS because they don't like what they are doing. Now, assume that's all true, Ms. Mitchell. Is that a fair statement that it was, would you call it persecution or what would you call all that?
Well, I don't think it was a coincidence, if you're asking that. And I might add that the IRS also subjected, and I can say this because Catherine, Ms. Engelbrecht testified before the House, one of the House committees about this. She also, she and her husband were subjected to individual personal audits by the IRS, as well as their family business being subject to audit by the IRS, and all that
And never
came
had
about,
been, never had been audited before, ever, in their entire lives with the business.
it all came about after she submitted applications for the C4 status for King Street Patriots and the C3 application for To the Vote.
And they were investigated by OSHA as well, were they not? Never before
All
happened.
surprise visits, surprise visits.
And right now, today, is there law to prevent the IRS from doing that again to somebody else out there?
Well, that's exactly what I'm saying. The Constitution, the First Amendment, and we have an action pending, and Judge Sintel from the D.C. Circuit, it was our appeal last week at the oral argument on our appeal in which he made those comments. We're before a 3-judge panel. I mean, we've sued the IRS, and we've also sued on behalf of True the Vote, and we've sued individual employees of the IRS. Now, one of the things that really, I have to tell you, galls me is not only has no one been held accountable, but we, the taxpayers, are paying the legal fees of the private attorneys who are defending the individual IRS agents in this litigation. So, you know, until we have to find ways to hold individual federal employees accountable and responsible when they violate the constitutional rights of citizens.
Reclaim my time because I'm about out of it. Nobody's been fired, to your knowledge, in the IRS. Some people might have gotten bonuses. Nobody's gone to jail.
No.
And don't you think this is, I mean, appalling that our government would use Soviet-style persecution of people who disagree and want to exercise the First Amendment freedom of speech? Don't you think that's a sad state of affairs with the IRS?
It's outrageous.
I yield back, Mr. Chairman.
Gentleman from Texas yields back. The chair now recognizes the patient gentleman from Idaho, Mr. Labrador.
Thank you, Mr. Chairman. Mr. Grossman, we've been following the ongoing Waters of the U.S. Regulations. The internal memos from the Army Corps of Engineers have stated that the EPA's definition is likely indefensible in court. Yet the EPA is continuing to move forward. Does this constitute, in your opinion, an overreach by the administration?
Yes, it does. You know, the key precedent in this area is the Supreme Court's Rapinos decision, and while fractured, the controlling opinion was arguably Justice Kennedy's, and I think as most legal analysts to view this rule have recognized, the Waters of the United States rule goes well beyond anything that would be authorized by Justice Kennedy's opinion, to the point that isolated puddles and things like that would be subject to federal jurisdiction.
Thank you. Do you think that Chevron provides the EPA the apparent authority to act in this manner?
You know, look, Chevron puts a thumb on the scale in favor of an agency in basically every case involving statutory interpretation, or at least a lot of them. But in this instance, it simply goes well beyond anything that would be acceptable, even giving the agency Chevron deference. This case raises, at heart, serious constitutional issues about limits on federal power and about limitations under the Clean Water Act. The Supreme Court has recognized that, as broad as that act may be, it is not infinitely capacious. And the Waters of the United States rule simply goes well above and beyond anything that the courts have recognized as legitimate.
Thank you. While the Waters of the U.S. regulations are a big issue today, there are smaller areas where the EPA is acting in the same manner. Can you name any of those areas where the EPA is acting in the same manner and impacting Americans without bothering to wait for congressional authority?
Well, gosh. You know, obviously the foremost one is the EPA's, many headed set of actions regarding greenhouse gas emissions. You know, the Congress in 2009 rejected a cap-and-trade scheme that was put forward by the administration, and the administration has subsequently discovered that it can impose the same regulations on the U.S. economy simply by fiat. under statutory authority that's been buried in the Clean Air Act since the 1970s. I think this came as a surprise to many members of Congress, but it also came as a surprise to people familiar with the Clean Air Act, given that the agency's understanding of its statutory authority under that act never encompassed these kinds of actions at all. While the Supreme Court in Massachusetts versus EPA may have given the agency some license to peek into greenhouse gas regulations under certain Clean Air Act programs, the type of cap and trade system that the agency is trying to implement in its Clean Power Plan just is insupportable, and to my mind is the kind of thing that really demonstrates what's wrong with the current aggressive posture of agency statutory interpretation that we now live with.
Excellent. I was also made aware that the EPA admitted wrongdoing in funding a social media campaign to support its Water of the U.S. Regulations. This is a clear violation of federal law, but yet the EPA still went forward with the campaign, as you know. This is another example of an agency exercising far too much authority. How can we rein in these agencies?
Well, first I would say, the social media campaign operated by EPA, it's not only that it was illegal, it was also wrong. EPA was acting, in effect, to mislead the public about support for its own actions. And, there should never be a circumstance when an agency of the United States government is acting to mislead the public. As to what Congress can do about this, my testimony describes a number of different possible alternatives, but, at heart, Congress needs to step forward and it needs to reclaim its legislative authority. The executive branch is always going to be the portion of government that has the greatest agility, but this branch of government is the one that actually wields the power. It has the power of the purse and it has the legislative power, and those are very powerful things indeed. Too often, Congress has delegated to the executive branch, particularly legislative authority, and has been unwilling to exercise its power of the purse in any forceful fashion. Congress can certainly do a lot of things to change the balance of power between the branches, but those are really at the heart of it, where efforts should be directed.
Mr. Bernstein, I think the administrative state has swelled to proportions well beyond the original intent of the Administrative Procedures Act. Can this or any other Congress regain its authority without a major overhaul of the APA?
That's a very profound question. I think the first thing we need to do is to enforce the APA itself, and I think there needs to be a way for, like, these universities, for example, the example I gave earlier that are subject to this Dear Colleague letter, to be able to challenge that. Right now the problem is you get guidance from the agency, or you get sort of informal prosecutions from the agency. We'll go after you if you don't do this or that, and you want to go to court, but there's no formal regulation that the courts could review. The agency claims we're not acting in a official legal manner, so there's nothing for the courts to do. So I think part of the answer has to be, as other people mentioned, less Chevron deference on that hand, but also more of a willingness of courts to allow people to proactively say, look, the agency is saying it's not official rule, but they're telling us that we have to comply. Don't look at the formality, look at what the agency is actually doing. And once we get to that stage, if the courts could do that, I'm not sure how much more changes to the APA itself we necessarily need.
Thank you. I yield back.
Gentleman from Idaho yields back. Seeing no further business to come before this, the gentleman from Georgia has arrived. In that case, we'll recognize the gentleman from Georgia, my friend, Mr. Hank Johnson.
Thank you, Mr. Chairman. The preamble of the Constitution of the United States of America lists one overarching theme, which is to establish or to ensure a more perfect union. So, and then 5 things that they wanted to do in order to ensure a more perfect union, which was to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and ensure the blessings of liberty to ourselves and our posterity. And I must express my complete dismay in this task force's disregard of those ideals by targeting the legal administrative agency action created to clarify the previously complex and rigid work requirements in the Temporary Assistance for Needy Families program, otherwise known as TANF. The laser focus of this task force is to dismantle guidelines that would provide states greater flexibility in determining its work requirements in the program, and this is nothing more than just conservative politics against poor people. In my home state of Georgia, the TANF program has assisted over 50,000 low-income families in obtaining food and basic necessities. That's what it does right now. Prior to the issuance of the 2012 Health and Human Services Guidance, TANF was the only employment program in which getting participants into permanent paid employment was not a key measure of success. States have devoted significant time to tracking hours rather than providing direct service to individuals, which could help them improve their prospects for securing employment or helping them become more job ready. Moreover, participation in basic education was not a priority. Finishing college degree requirements did not count as a standalone activity that would allow single-parent households to continue receiving benefits. The previous work rate requirements heavily constrained a state's ability to use training and education, even where the evidence shows stronger employment outcomes for those who complete those programs. The administration's lawful changes to the TANF program challenge the lawful changes to the TANF program challenged states to engage in a new round of innovation that sought to find more effective mechanisms for helping families succeed in employment. I was mistaken. I would hope that this task force would immediately cease wasting taxpayer dollars debating legal rhetoric and start assisting everyday Americans. And with that, I would like to ask of Ms. Emily Hammond, were there any questions that were asked of you that you were not able to answer fully and which you desire to address while you have the time right now?
Thank you very much, sir. I would like to just respond to some of the suggestions that we do away with Chevron deference as a way of constraining agencies. I've previously, again, testified here that doing away with Chevron deference is a piecemeal and likely unrealistic approach to trying to enhance legislative oversight of what the executive branch does. What I would ask this institution to do is something that I think my co-panelists would agree with, which is to draft statutes clearly in the first place so that agencies can follow that direction. Right now, the agencies are doing the best they can. For example, with the waters of the United States, I disagree with my co-panelist. I do believe that rule stays within the bounds of Justice Kennedy's opinion and should be upheld on review. The point is the courts are doing their job. Chevron enables them to do their job, but still polices those statutory boundaries. Thank you.
Thank you. And I'll note that you are hailing from Georgia. Welcome to Washington, D.C. once again. Good to see you. Thank you. And I yield back, Mr.
Chair, thanks, the gentleman from Georgia. And this concludes today's hearing. I thank all the witnesses for your testimony here today. And without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. I thank the witnesses again, and I thank the members in the audience. This hearing is adjourned.